Welcome to you all to this webcast come podcast, and my name is Jonathan Senior, the chairman of Very Smart. Very Smart, for those of you who do not know who we are, is a nationwide property inspection organization specializing in inventories and related inspections and reports, as well as housing health and safety rating system assessments for the private rented sector. We at Very Smart currently serve around 3,500 clients, and we find that there is some confusion as well as a few false assumptions regarding current housing legislation in the context of the HHSRS and the fitness for human habitation. And to help overcome some of this, I've invited an experienced and highly qualified guest to explain what are some of the pitfalls and perils associated with fitness for human habitation and what the implications might be by not complying with this legislation. My guest is a gentleman called Dick Scott, and Dick is a housing and health consultant with 30 years of local authority experience in London and the Southwest, plus a further 10 years of private sector consultancy under his belt. He's an accredited housing health and safety rating system assessor and trainer with a background in housing enforcement work, affordable housing and energy efficiency, and training people across the housing spectrum. He's also a chartered environmental health practitioner and a member of the Chartered Institute of Environmental Health's think tank, which is their National Housing Advisory Panel. So welcome, Dick, and now over to you.
Before I start, though, I need to make it clear that these are my personal views. I'm not speaking on behalf of anyone, and my views aren't necessarily the same as those of the Chartered Institute of Environmental Health. So there's the usual caveat. Anyone intending to take action based on fitness for human habitation should first make sure that they've checked all the facts and have up-to-date information. So, how does the Act work? Well, to give it its full title, the Homes Fitness for Human Habitation Act 2018 has come into force in 2 stages. And at the second stage, from the 20th of March this year, nearly all tenancies are now covered by the Act. And the big exceptions are obviously things like lodgers, licensees, that sort of thing. Now, in a nutshell, the aim of the Act is that a tenant can take their landlord to court for repairs and/or damages if they think that their accommodation is unfit to live in. Superficially, it makes some simple changes to existing law. It makes 3 apparently innocuous changes to the Landlord and Tenant Act, 1985, but like any of these things, the devil is in the detail. The first change is to remove any rental limits for using that particular part of the Landlord and Tenant Act. The rental limit used to be so low that no one was able to use it. The second is to broaden its coverage so that the tenants of registered housing providers can also complain about conditions and take their landlords to court. And the third is to include the Housing Health and Safety Rating System, the HHSRS, in the list of factors that could make a property unfit to live in. Now, these are pretty big changes. The Act already had a list of 9 specific factors to consider. These could be described as comfort or convenience factors, including things like repair, stability, dampness, as well as light and ventilation. However, the Fitness for Human Habitation Act added in the HHSRS, another list of 29 headings under which risk and danger to health are considered. And just to complicate the issue, the 29 HHSRS factors also include several that overlap the 9 original fitness items, so that in some areas fitness could be a pass or fail issue, or alternatively, it could be a too dangerous issue for the same things. Now, the government has issued some guidance to landlords and tenants, in which the process itself is straightforward. If a tenant's worried about something, they have to put it in writing to the landlord, explaining what the issue is and allowing reasonable time for the landlord to react. Now, the Act doesn't specify what a reasonable time is, but it is being interpreted by many as 14 days. If the landlord doesn't do anything, the tenant has to write again, listing the issues, explaining how it has affected them, stating when they previously complained, and allowing another slot of reasonable time again. At this point, if the landlord still does nothing, the tenant can take them to court, to the county or high court. The court then decides whether it considers the property to be unfit for human habitation. If it agrees that it is, then it can require that the landlord repairs or corrects the situation, and it can award damages and costs. Now, there are a few important things to note. The first is that, as with the HHSRS, fitness for human habitation covers the whole house and its immediate surrounds, as well as the shared amenities and access in houses in multiple occupation. Next, landlords have a reasonable time to respond if the property is let to a single household, but in multiple occupancy, the landlord is immediately liable for issues in the common parts. This means that as soon as they're aware of anything that might make a property unfit to live in, they have to act, fix it, or tell the person with ultimate responsibility, like the freeholder, as soon as possible, to pass the responsibility over. Finally, although a lot of people are under the impression that unfitness only refers to the actual occupier, the courts are going to be considering the impact on any potential occupier or visitor when they're judging fitness for human habitation, as the HHSRS assessment already does. It's only the costs and the damages that will be considered against the actual occupier. So, a landlord can't assume that their tenant would not be affected by the particular issue. They have to consider the worst case scenario. Will it affect visiting older relatives, small children? I'll talk a bit more about this later on, but I think that the way the Act is used is likely to unfold bit by bit, delayed a little by coronavirus, but as the boundaries are pushed by solicitors, it's going to get wider and wider. Now, why was it brought in? On the face of it, the Act was a very good idea to plug some gaping holes in the protection of tenants. In private rentals, the tenants could call in the council if the property seemed dangerous, and there was the possibility of claiming damages if the landlord failed to keep a property in good repair. However, tenants of council-owned properties couldn't get the council to act against itself, and in any case, many councils were often under-resourced and overstretched for dealing with complaints. Well, the Act changed all that. Tenants in nearly all tenures, whether in council housing, housing association properties, or the private rental sector, are covered by the Act, irrespective of rental levels. Moreover, the government's guidance explicitly says that a council or formal survey isn't necessary. So in theory, tenants don't have to pay to get action. It's a simple process to start. So what are the disadvantages? Well, the biggest problem is that this hasn't really been thought through. First, who's going to help the tenants to take action? From the outset, in January last year, 2019, the then Housing Minister, Heather Wheeler, was saying that the government expected it to be handled on a no-win, no-fee basis. This ties in with the fact that cases go to county or high court. Damages can be claimed, but so can fees. Putting this into the hands of claims management companies and solicitors on a no-win, no-fee basis means that the same companies that lost a lot of business when PPI ended now have a new, potentially lucrative source of income. And as anyone who's been on the receiving end of a car insurance claim will know, this could mean a lot of sleepless nights. With car insurance, a lot of people simply pay up rather than fight the case. But we have a mix of standards, wording that's wide open to interpretation, and some very vague guidance. There are a lot of myths and assumptions out there, and some of these need dispelling. Myth number 1, landlords have 14 days notice from the first complaint, then another 14 days to fix it, a whole month. As I mentioned earlier on, people have latched on to the idea that reasonable time allowed to fix things is 14 days, but it isn't specified in the guidance. In reality, a court looking at a landlord's response may want to see that they dealt with urgent issues quickly. It may not be considered reasonable to wait 14 days to deal with, say, no hot water in midwinter. Myth number 2. The only standard that will be enforced is the HHSRS. Again, some people are stating that fitness is only about the HHSRS. They've completely forgotten the other 9 standards in the Act because the guidance says nothing about them. And this is a pretty dangerous assumption. People are forgetting that the 9-point fitness standard was the basic national housing standard before the HHSRS replaced it in 2004. They assumed that because there's only detailed guidance for the HHSRS, then this will be the only enforceable part of the legislation. And in addition, a lot of the focus has been on looking for parallels and precedents. For example, recently some solicitors have been giving advice drawing on the Defective Premises Act and Section 11 of the Landlords and Tenants Act, the repairing obligations, where damages have been awarded mainly based on the loss of amenity. They're overlooking a very significant factor. In 1985, there were two parallel pieces of legislation in force. The Landlord and Tenant Act, 1985, this now amended Act, and the Housing Act 1985, which itself was amended in 1989, and then, as I alluded to, mainly replaced in 2004 by a new Housing Act. So you have two parallel pieces of legislation. The Landlord and Tenant Act was the vehicle for tenants to take action about the fitness standard, while a nearly identical list of 9 fitness factors in the Housing Act was enforced by local councils. The Landlord and Tenant Act was interpreted by the courts on the basis of precedent, earlier court decisions, which are quite thin on the ground. But council staff had a book of very detailed guidance from the government about how to interpret fitness for human habitation in their act, the Housing Act. And the guidance was something called Circular 1796. Now, it's very likely that the first cases will be about the HHSRS. After all, it's a well-known process, and a Category 1 HHSRS hazard will implicitly make a property unfit for human habitation. But after that, any decent solicitors will be looking at the Housing Act guidance to take cases to court under the other 9 fitness for human habitation factors. As the Housing Act factors were nearly identical to those in the Landlord and Tenant Act, there is an argument to say that detailed guidance already exists about what is and what isn't fit for human habitation. Moreover, this isn't necessarily about loss of amenity, because damage or disrepair, which is the loss of amenity argument, may not be relevant to this. Some of the features that make a property unfit for habitation may well have been built like that. Now, unfortunately, this is Pandora's box. While the HHSRS part is about risk assessment, the dangers from the property, the Circular 1796 guidance that I mentioned for the other 9 factors covers a mix of absolutes, like habitable rooms needing windows 1/10 of the floor area, comfort issues, including rising and penetrating dampness, and even severe inconvenience from disrepair. Here, the Act could blow up in everyone's faces, because there is a key phrase. The property has to be so far defective in one or more of the 10 factors that it is not reasonably suitable for occupation. Once cases come to court about these issues, then they could become a black hole of legal arguments and fees and a lot of time. Myth number 3, it's only about things that can affect the tenant who actually lives there. Well, this is a straight no. I did mention this earlier too. It is easy to think that if you have got a robust young tenant who's fairly bulletproof, then conditions need to be worse to make it unfit for them to live there. And the Act does have a clause that sounds as if it's only about the resident tenant, but this doesn't relate to the assessment of whether the property is unfit for human habitation. This is only about whether that tenant can take damages for loss to themselves. In fact, if you take a look at the 10 factors to be taken into account, the guidance to assessing the original 9 factors is clear. It's not just about the resident tenant. The judgment is about whether it is reasonably suitable for habitation, has to be assessed for anyone who might visit or live there. Equally important, the Act lists the HHSRS, that 10th factor, in terms of prescribed hazards. That means that any of the 29 HHSRS factors have to be assessed using the normal HHSRS assessment process. So this means that each issue has to be judged by the most vulnerable age group that might be affected by the issue, not the person who actually lives there. In short, You may have a young rugby-playing tenant who you feel can cope with steep, uneven stairs, but the HHSRS assessment has to take into account older people, the most vulnerable group for steep stairs. If the assessment says that it's a Category 1 hazard for that group, then the property is likely to be considered unfit for human habitation, irrespective of who lives there. So, what can landlords and agents do to protect themselves? Well, obviously, the first thing is to take the Act seriously. Ignore the myths and rumours. Cases under the Act will probably proliferate, but to begin with, claims companies and lawyers will go for easy wins. They'll probably start with council, housing association, and large property portfolios where management has become lax and surveying is generic, using surveys of one property to represent several or a group of similar build and age. Generic surveys are only good for factors like energy efficiency, where similar boilers, windows, and insulation has been installed. They're useless for individual conditions and disrepair, or where property has been customized. So the first thing to do is to have individual surveys done for HHSRS and fitness to update any generic ones. It's important to get independent, objective surveys, even for single properties and small portfolios, because it's very easy to get blasé about things you see on every visit and with every successive tenant at the same property. They become invisible. The next is to stay on top of complaints. Even a text is a written complaint. Take them seriously, because the next complaint will be the last one. Have a scale of response times. Urgent issues need fixing urgently. Make sure that anyone visiting the property on behalf of the landlord knows how to refer issues quickly and who to, especially people not thought of normally. Cleaners, decorators, handymen, inventory clerks. Any one of them might get a complaint, but it might not be in the form you expect. It could just be a scribble on the back of an envelope. Agents need delegated powers to fix things. They need a budget, particularly when the landlord's away, or they need somebody who has authority to spend to sort things out. You only get 2 chances to fix things under this Act. Finally, be proactive. Remember that all visits to the property, particularly midterms, can be used to get up-to-date information on conditions at the property. Anyone who visits, for whatever reason, should be updating the records. But most of all, though, and I'd emphasize this again, reports need to be objective and independent. They're important as an evidence trail for deposit arbitration, and the objectivity and accuracy is just as important for fitness for human habitation. And that's it. Thank you.
Well, there we have it. And I hope that those of you who have watched or listened to this have found good value.